In my intervention, I'll try to identify some open questions concerning the application of personal data protection. This is the outline. I don't think we have time to go into detail, so I'll try to be very short in presenting each of the questions. The first one is, do we want to protect personal data or we want to protect identity? Second question, what is anonymous data? Third question, is the informed consent effective? Then, do we need a new right to oblivion? Which is the relation between technology and law? Which is the applicable law in the international data flow? Can we propose a new model called accountability? These are the questions I'd like to address shortly. The first one, what do we want to protect? Information or person? Is identity simply a sum of personal information, or is something different? I think that maybe we want to protect both, and I think that probably identity is not just the sum of some correct information about a person. It's something more. It's the whole picture, and a person has the right of not having the whole picture distorted. This has been recognized by some European legislation as the right to personal identity, different from the right to personal data protection. The second question is, what is anonymous data? The question is crucial because, as you know, if data is anonymous, then data protection law does not apply. So, defining anonymous data is of central importance. The definition of anonymous data is not easy to be given, and the concept is extremely controversial. A definition of anonymous data is not included in the directives, but there is a reference to anonymity, providing that to determine whether a person is identifiable, account should be taken of all the means likely reasonably to be used either by the controller or by any other person to identify the said person. The definition of personal data is the starting point to define anonymous data. Anonymous data is defined based on the ability to connect data to data subject. Information cannot be considered identifiable if identification requires a reasonable amount of time and manpower. In case where the individual is not identifiable, the data are referred to as anonymous. Introducing reasonableness in the definition means considering anonymity relative. I think that the measurability of different degrees of anonymity and the consequential classification of data based on these measures could be a basis for an effective protection of personal data. In the past, a person could be anonymous by choice. Today, technology makes it more and more difficult to remain anonymous. Electronic activities always leave traces, carrying mobile phones, paying with a credit card, using a PC, using a PDA, and so on. And connectivity is not a goal today, but a simple way to act. Therefore, I don't think that anonymity can be anonymity 100%. Third question. The directive on personal data protection, the directives on personal data protection are based on information and consent. However, it is a common opinion that in many cases this system is not effective. The data subject in many cases is not in the position of refusing a consent. For instance, if a service or a good is needed, it is unlikely that the data subject will deny consent. On the meantime, it is easy to verify that if the consent is a simple click, it will be given, in most cases, without thinking about. There is a problem of awareness in giving consent. If data processing is connecting to a technological device, it is part of a technological chain, then giving consent is difficult and without effective significance. Think, for instance, about cloud computing. I think that security measures and responsibility have to be strengthened apart from the consent. The fourth question I like to address is the right to oblivion. The book Delete, published in 2009 by Victor Meyer-Schönberger, has opened a discussion on the right to oblivion. To be precise, the book does not claim for a new right to oblivion. It emphasizes the virtue of forgetting in the digital age. The problem to delete from Internet, as it does not forget information, is a real problem. Moreover, in the Internet, there is a problem of information quality and sources of information, not always trustable and recognizable. Does it require a new right to oblivion? I don't think so. In this case, I don't think we need new provisions. There are already provisions in data protection law. What we need is to make effective the provision. This is a problem not to be solved through law, but through technology. Meyer-Schönberger proposes to provide a sort of expiration date for information, and in any case, whatever the solution, technology in this case is essential. Technologies already available are many, for instance, DRM, digital rights management. It has information to be associated to personal data. This leads us to another topic, the relation between technology and law, the so-called Lex Informatica, a way to make law effective through technology. This argument has been introduced by Lessing and by Professor Reidenberg. And I think that a joint approach, legal and technological, should be used to measure anonymity, for instance, and that a protection of personal data based on security should be at the basis of the development of technological device. Which applicable law? As you know, the directive on data protection provides criteria concerning the applicable law, but these criteria are not always very clear. Think, for instance, at a very recent case decided by the Tribunal of Milan, quite famous, Google versus Vividown. In this case, the competence of the Tribunal of Milan was uncertain, so to say, if we apply data protection directive. Last question is what about accountability? It could be a new model to be introduced. It is the responsibility to adopt effective technological and organizative measures inside an organization and to demonstrate it. It can be a new source of responsibility. It can be a way to apply law already in force. And it can be a way to make data protection law uniform at the international level. Thank you very much for your attention.